This is Australia, so I've got to stop saying good morning and say g'day, mate. Apparently, that's how you do it. Right. And in reference to a nice little gentleman who decided he knew everything about everything, I have spoken to you before. Everything you put on my posts in your big rant about the authenticity of things according to you was lawyer crap. It isn't law, it never was law, and you were just trying to put your point of view. Unfortunately, what you put had nothing to do with the subject matter, so it was removed. Which you've got to understand, and you will now, is my right to do. Remove what I consider nonsense. You see, this site deals in law and opinions based on law, not the whims of lawyers who swear an oath to lie for the better good, and their actions prove that's exactly what they do in a lot of cases. So, not to deal with that. In relation to local government, is it lawful? Well, Sydney Municipal Council versus the Commonwealth in 1904, HCA 50 1904, 1 CLR 208, handed down the 26th of April 1904, literally denied the state of New South Wales from having able to tax your land belonging to the Commonwealth. Well, we're the Commonwealth. How far that extends, it doesn't say. But the principles that come out in that case, if you sit down and take the time to read them, by the way, the three people who sat on it were Chief Justice, Justice, and another Justice. All three were framers of the Constitution, were fully conversant with what they were dealing with. But what was not put before the court was the fact in August 1902, New South Wales, who brought the case, the Municipal Council brought the case, but New South Wales had removed its constitution, replaced it in direct contravention of 106 of the Constitution. It's gone. The state, nothing what the state did after that is lawful. Why do I say that? Because the state constitution continues subject to the Commonwealth Constitution. Now, I don't fully agree constitutionally with the decision of the court. That's my right. If I was to go and argue that case, I'd argue it a different way. Now, the next one is Commonwealth versus New South Wales, 1923. That depicted fee simple, what it meant, and everything, how it's explained, and where it is in Chalice property, and the fact that it alienates the land from the Crown. Well, apparently, the Western Australian Local Government Act, when they seize your land and take it away, it's alienated from the Crown on behalf of them. How nice. But it isn't when we buy it, apparently, according to them. Another joke. But again, New South Wales didn't exist in 1923 and still does not to this day. And as I said yesterday, they decide their magistrates were now judges and added it to the 1902 Constitution, admitting fully that the Constitution they are using is not only fraud, it's treason, directly against 106 of the Constitution. Remembering they were allowed to retain their constitutions subject to the Commonwealth Constitution being a fact. Now, Julie Wager, who sat on my case in the District Court, said she's not bound by the dicta of Isaacs. In other words, I'm going to disobey a ruling of the High Court, which is clearly criminal contempt of the High Court. I don't care what you think, Julie Wager. You can try and bring me before the District Court because somehow now you think you are the Chief Justice of the District Court. Well, if you are still or whatever, I don't really give a hang. I don't give a hang because it's all nonsense. You're a quorum. You always were a quorum. Says so on the document. A quorum is an unelected judge, a person impersonating a judge who isn't one. Being the fact that Western Australia was not lawfully constituted, and I've given the reasons before. I'm not keep going back in it. And all the elected so-called members weren't elected according to the law. So it doesn't exist. So your decision is nonsense. The decision after that by 3 more quorums in the Supreme Court, who sat without the authority of the Crown, and somehow this gentleman yesterday and Brian Shaw decided we won't go back to 1901. We'll start in the middle of the treachery committed by the Parliament and we'll deal with issues after that. I was contacted or tried to contact by people I know involved with Brian Shaw. I don't care. When an offence is committed, it starts on the first date it's committed. January the 1st, 1901, the whole of Western Australia was not constituted. It was created under 107, 108 and 109, but it needed compliance with 107 to draw the authorities granted. It didn't do it, and still hasn't, and now they create an entity known as the state, a fraud. Now, the reason I brought this up again, you need to comprehend what this means. If only the governor can run an election, and this says he can, if only the governor can accept and put up candidates, this says he can, and if only the governor can run the complete election through the civil service, which is under his control, not under a parliament, it's under the executive and the executive council. We don't have either. So what you've created in this state, Dodgy Roger and your counterparts, and all the other political parties since Federation, when they first overthrew the Commonwealth Constitution, what you achieved is the Commonwealth Parliament has never been lawfully established. You can't say it can't because you can't prove it. I say it hasn't because I can prove it. What you're trying to say, oh, little silly old bugger, I've been called 100 times. Once you get off there, why don't you stop telling people what's not true? I'm not teaching lawyer truth. I'm not teaching quorum truth because there's no judges. I'm not teaching politician truth. I'm talking constitutional reality and truth. Now, Fijo versus the Northern Territory said that native title does not overthrow fee simple owner. So, good old Dodgy Roger, you and your clan of misfits, you decided if we want to dispute anything that you do, we have to take it to court. No, we don't. You don't have any lawful courts to take it to. I tried that. They ruled against, in the case of Julie Wager in the District Court, Western Australia, in Glew versus the Granite Shire, she sat there and threw out a decision of the High Court saying it's just the dicta of Isaacs. It's not the dicta of Isaacs. Julie Wager, you had no right to be there. It doesn't worry me that you are there, but you sat in treason. You sat in criminal contempt of the High Court by your statement, and I've got the documents which prove it. And in relation to Wheeler, Pullen and Bus, you did the same. And Wheeler, you stated in Headley versus Spivey, I've got a commission from the government. If that's not on the transcript like someone's suggesting it is, I don't care. We were there. We, the people, were there with several witnesses. Now, in 2019, I defeated City of Greater Geraldton. And this is interesting because it came up a couple of days ago when so-called police who are public officers and not officers of the Crown according to Justice Kirby, they're creatures of statute, and it wasn't denied in court in Geraldton when I put it to the police and I put it to the court. In fact, I proved they were public officers, creatures of statute. You can never be an officer of the Crown. That's a ruling of a Justice of the High Court. Interesting? Yeah. Well, we now have a huge problem because we have an ex-police prosecuting sergeant, I'm not going to repeat his name again, who thought he had the right to just walk on people's property with a piece of paper written on it, warrant. But it doesn't meet any of the requirements of a warrant, none of it. So you trespassed, and for that a formal complaint will be made to Geraldton. I don't think there's not much going to happen about it, but it'll be made. And if you do nothing, it'll be made public. It's a huge public interest that if the police do nothing about a blatant disregard for the law, you have to have a lawful warrant issued under the Crown that has to be accompanied by an affidavit. Neither was on that document. That is not a copy of the document you presented to be signed by a JP. No name of the JP, no signature. If you wanted that not made available, you could black it out like you do on others. So you say. But when subjected to a test, it was never on there, meaning it's not a copy. I'm allowed to check a warrant. Anybody else is allowed to check a warrant issued against people to enter their property. The police do not have a standing warrant to follow you on there. They had a duty, all of them that attended, to make sure that warrant was lawful. Because you were an ex-police prosecutor and a senior sergeant or a sergeant, you relied on your reputation to disobey the laws of this country, and you did that. You entered property without lawful excuse. How do I know? I'll just read you a couple of cases which actually refer to what I'm saying, and you can look them up yourself, because this clearly explains that you're lying. It's all against trespass and the rules that comply with it. The first one is Glew versus the State of New South Wales, 2008 HCA 26. New South Wales versus Ibbott, 2006 HCA 57. Plenty versus Dillon, 1991 HCA 5. George versus Rocket, HCA 26, 1990. Halliday versus Neville, 1984, HCA 80. These are all cases which prove what I just said about trespass applies. How do I know? Because decisions of the High Court, once published, and they all are, form part of the common law. They're binding on the courts, judges, and people of every state. So if you're a people, or you're exercising authority, or you sit as a judge or a magistrate anywhere in this country, or you say you create a court, you are bound by the decisions of the High Court. It doesn't say they cut off after so many years. The Australia Act does not exist, never went to the people in the form of a referendum, and has no value, but we didn't have a federal parliament to put it there. Nor did we have any states to confer that authority on the federal parliament if it did exist. They were all gone by 1975. I didn't make this stuff up. This is the law. And yous are lying and committing fraud. And when an arrogant piece of work comes and decides he can just lie, cheat and steal, the warrant allowed you to enter the property if it was lawful, and it wasn't. To enter the property to check out that building. The building has stood for 14 years. It has been hit with all sorts of huge winds in Geraldton, because that's what you get here, whether you like it or not. And the big problem you have is you decided you were going to push your ideas and you were going to do what you wanted. Nobody resisted you. You were told several times, you were told in no uncertain terms by the owner to F off, get off the property, you got no lawful right. You were fully aware, or should be. If you exercise authority, you have to know the law in relation to that authority. Now, and this is a newsletter written by somebody, and it clearly states the contents of the issue of fee simple. And there's 4 elements of ownership that are carried in a fee simple title deed. Now, every title is in fee simple, has nothing to do with the government, never did. Never did. Did you have control over land? No. Only on just terms for public use. Now, the first issue of ownership is tenements. Second, messuages. 3, corporeal herediments. 4, incorporated herediments. First, we must remember that many words have different legal words or had different original meanings to our current understanding. Therefore, the word tenement in one does not mean a hovel shack in a narrow sense. It simply means buildings. However, in the broader sense, as attached to fee simple grant, it means not only the land but everything of a permanent and solid nature attached to the land, so the buildings, the roads, the rents, the leases, whatever, and they are all attached to the land. 2, messuages is a term for dwelling house. In essence, this ownership right is permission to build and live on the land. We don't need a permit from you. Laws of good governance would insist that it was engineer approved. Well, we don't need an engineer approval if we build it ourselves. Fact. And you can't change that. At 3 and 4, we come to the herediments. These are things capable of being inherited, including not only land, but everything thereon. Corporeal herediments are the tangible physical elements of that inheritance. According to Blackstone's Commentaries on English Law, 1765, still used in the High Court of Australia today, this consists of substantial and permanent elements of the land, the ground, soil, or earth whatsoever, as arable, meadows, pastures, woods, moors, waters, marshes, furzes, and heath. It legally includes buildings as they use the land as their foundation. Water cannot be owned, but the land which holds it can. In its legal significance, land has an indefinite extent both upwards and downwards to the centre of the earth. That is a complete breakdown of fee simple according to Chalice Real Property 3rd edition. So, in relation to local government, which is a company, and it is set up as a corporation according to then, if it was lawful at federation, we would have reference to control over land. It doesn't give them. It gives the states, which are created under the Constitution of Western Australia, never was, and all the others rejected it. Also, they dumped their authority over land if it ever was, but they didn't have it. The states were given the right to set up municipal authorities, like there was before federation. A municipal authority looks after roads, footpaths, and parks. Nothing more. If you decide you want them to have more, put it to the people. You put it to us that therefore we would be able to do what we want, and you could do what you want. You wanted to continue local government. We said no. You wanted to establish. We said no. You wanted to empower them. We said no. You wanted to allow them to make bylaws. We said no. The people, it wasn't just not continued, it was denied. Supreme, absolute and uncontrollable authority remains with the people. We denied you the right to continue it, establishment, empower it, and authorise it to make laws. So you don't have it. But the referendum was put together by a pack of morons. claiming to be the federal parliament, which they weren't. And in Albo's case, Anthony Ellery, because you haven't proved yet, I asked you to prove it. Did you change your name by deed poll? Prove it, because I don't believe you did. You were 46 when you went to Italy, which means you create a problem by accepting that your father is in Italy. Did you get naturalised into this country? Has to be shown. If you didn't, you got joint citizenship, the ability to go back to Italy as an Italian citizen. You clarify it, because I'm challenging you to tell the truth. The sound keeps disappearing. That's the stupid internet. That's the beauty of having a public utility sold off to a pack of clowns can't even run it properly. I'm not going to answer that, Gary McDonald. This is an issue in relation to local government. If we took over the parliament and created a lawful parliament, it would have to go back to the original one, and the other piece of junk pulled down because of its satanic influences. So I'm not getting involved in what you're doing. We're dealing with fee simple. You can't deal with it, then go away, please. I'm not insulting you. I'm telling you, go away. We're dealing with fee simple and local government, because there's none exist. The local government before federation were the individual 6 parliaments of the 6 colonies, which ceased to exist on the proclamation of the Constitution. Local government after that is the 6 parliaments created by 107, 108 and 109. If you can't comprehend that, or you say it's a different way, prove it. They're the local government. Now, when you read the Constitution and Chapter 1 and Chapter 2, part of Chapter 2, it explains the state parliament is an inferior parliament to the Commonwealth one. The Commonwealth parliament is an inferior parliament to English parliament. We are, under Clause 8, a self-governing colony of England. You want that changed, put it again to the people. But you first, because we have an enabling act sitting across the top, the monarch has to remove that act and the letters patents that go with it. First, only on the application of the people. Someone says, oh, the Australia Act, English and Australian, she signed it. Doesn't matter if she signed it. The Crown is bound by our Constitution. It's indissoluble, and it binds the Crown to any laws made under the Constitution. The Australia Act wasn't made under the Constitution. Doesn't matter how many times a professor, a person who tells lies for the government's sake, which is what most of them are now. I know a few that aren't, but a couple of them are, and if they'd read the Constitution, they'd know they were lying. Magistrates cannot override the law, override it. Judges cannot override the law. I feel that the government has the power to delegate powers. Well, what does it say in the Constitution? They can delegate powers from an elected body to a company they created to take money off us as a tax, which a company can't tax us. They can't tax us. If it can, show us in the Constitution where it says it can. Can it collect tax for the government? That then becomes a debatable thing. Because if you're already collecting tax in the area that you want, which you are, for roads, footpaths, and everything else, in fuel tax, and massively so. So you know you can't just switch and do what you like. You are bound by the Constitution. It's binding on everybody. Both houses of Parliament sit under the Constitution. The only way a court can exist excuse me, I'm getting a bit dry. The only way a court can exist and sit is inside the Commonwealth, held to the Constitution and the common law, both of England and common law created by the High Court decisions, if they comply with the Constitution. If they don't, we can ignore them with impunity. You cannot enforce them. And as for the Aboriginal Heritage Act, the Acquisition of Land Act, and all your issues you're bringing up, why aren't they dealt with in the High Court? Why do they go to the federal court? Because the 1999 referendum, put there by good old Jack Boot Johnny, took out the Mabo decision. Read it and look at what he did. Do I agree with it? No. I agree with the will of the people, because it's whereas the people, black, white, green, yellow, whatever they are, there are no black people in this country. They're a shiny purpley colour. They're dark brown, they're light brown, and they're like me, pink or white, depending on the weather, or blue if it gets cold. Now, stop being stupid. Wake up. You own your land. If you pay all that money for a block of land and you can't see that an idiot, supposedly representing you, like Dodgy Roger, says, oh, we passed an act, so we own the land. Look for the authority for that act. First, look for the authority to exist based on the law. You don't exist. You can't make those laws. Local Government Act was added in every state in 1979 to the Constitution of the state. Why? Because it never existed prior to that. And you know it. You tried to get us to concede and allow you to have it. We said no. Nor do we have to. You don't have control over the land. Laws of good governance would stop you building crap on your land and all sorts of stuff which would interfere with your neighbours. I get that. That's laws of good governance, which is all, both at state and federal level, you would have to do it. But there is no federal parliament. And literally, there are no lawful state parliaments. There's only one remedy: put all the state constitutions back in place, elect new governors, and it can't be from any of the clowns that are there now, or any of your mates and buddies. They would have to be elected by us or produced by the Crown of England, which is the superior law in this country. Like it or lump it, that's it. You want to change it, there's a method to do it, and you'll do it. You cannot go back to 1973 in the middle of a fence and say, we're only going to go forward from there because he did this, this and this. No. If you stole in 1901 and stole all that time, it's a continuing offence. You commit treason in 1901 and committed it all that time, and you still are. You're guilty of treason since Federation, regardless of whether